Three uniformed police officers entered a fenced-in backyard of a private home with their handguns drawn, but without a warrant. One of the officers scaled the fence. Another kicked in a padlocked gate to make the entry. But why? Well, because the neighbor called in and said there was a suspicious person in the neighbor's backyard. Well, it turns out that person is the owner of the property. When the officers make the arrest, they find some firearms. The individual is charged. But of course, he appeals and says that this was a violation of his Fourth Amendment rights. So today, we're going to discuss the Fourth Amendment, the one that protects you against unreasonable searches and seizures. We're going to talk about curtilage, the area that intimately surrounds the home. And finally, exigent circumstances exception to the warrant requirement under the Fourth Amendment. Welcome back to LAWSTACHE channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California. If you're new to the channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, stickers, and some other items. And finally, I'm a criminal defense attorney in California and Nevada. If you have a case that you want to discuss with me one-on-one, feel free to give me a call. Let's go on and talk about the Fourth Amendment. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing a Ninth Circuit case, United States v. Struckman. Now, in the introduction to this video, I gave you some brief description about this case. Three police officers make an entry to a fenced backyard and arrest the owner of the property. Here's the information that the officers had at the time of the entry. They received a call from a concerned neighbor who said that she saw a white male wearing a black jacket and a red backpack that he threw over the fence and then climbed over. She also told the officers that her neighbors should have been at work. When the officers arrived, one of them peeked over the fence and made a visual confirmation that Mr. Struckman matched the description provided by the caller. He was in fact wearing a black jacket, which he slowly took off, and there was a red backpack leaning against the porch. The officer took out his firearm and ordered Mr. Struckman to the ground. Mr. Struckman complied. At this point, the officer reholstered his weapon, climbed over the fence, and then took out his weapon one more time to make sure that Mr. Struckman does not flee. He puts him in handcuffs, pats him down, and finds a magazine to a firearm. The officers then search the backpack and find the firearm. In the meantime, Mr. Struckman continues to tell the officers that he lives at this property. This is his home. He also tells the officers that they can call his mother, who would confirm that Mr. Struckman lived at this address. Now the officers find out that Mr. Struckman was telling the truth. He was in fact living at this address. But they find this out after they already make the arrest and search Mr. Struckman. By this time, they also find out that Mr. Struckman is a former felon, and thus they charge him with being a felon in possession of a firearm against the federal felon in possession charge, 922G. Mr. Struckman receives a 17-year sentence, but he timely appeals, which is allowed under his plea agreement, because the lower court did not suppress the firearm. But Mr. Struckman tells the Ninth Circuit that this was an error. The firearm should have been suppressed because it was found in violation of his Fourth Amendment rights. Now remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct a search. Now here we're dealing with a warrantless search. The officers did not have a warrant when they made the entry into the fenced backyard. At the Fourth Amendment's very core stands the right of the person to retreat into his own home and there be free from unreasonable governmental intrusions. For that reason, searches and seizures inside a home without a warrant are presumptively unreasonable. The presumptive protection accorded to people at home extends to an outdoor areas traditionally known as curtilage, areas that, like the inside of the home, harbor the intimate activity associated with the sanctity of a person's home and the privacies of life. Now, there are two exceptions to the warrant requirement for home searches, that is, exigency and emergency. The emergency exception stems from the police officer's community caretaking function. Sometimes this exception is actually called community caretaking function, and allows them to respond to emergency situations that threaten life or limb. This exception does not derive from police officers' function as criminal investigators. By contrast, the exigency exception does derive from the police officer's investigatory function. It allows them to enter a home without a warrant if they have both probable cause to believe that a crime has been or is being committed and a reasonable belief that their entry is necessary to prevent the destruction of relevant evidence, the escape of the suspect, or some other consequence improperly frustrating legitimate law enforcement efforts. Now that you know the law, let's analyze the facts step by step. First, let's talk about the curtilage, the area that's intimately surrounding the home. Now, the court gives a little bit more information about curtilage to you. They tell us that there are 4 factors that we can take a look at: the proximity of the area claimed to be curtilage to the home, whether the area is included within the enclosure surrounding the home, the nature of the uses to which the property is put and that area is put, and the steps taken by the residents to protect the area from observation by the people outside. Now, the court says that without a doubt, this small backyard enclosed by the fence is the very definition of curtilage. Mr. Struckman had a fence around the property. It was tall enough where the officer needed to stand on something to peek over the fence, and so it is protected from the general public. And so the court says, without a question, this is curtilage. And thus, the Fourth Amendment protects Mr. Struckman in this area. So then we have to ask the next question. How can the officers enter this property? Well, they should have gotten a warrant, but they didn't. So the government has to rely on some exception. Here, there are 2 exceptions that the court mentions: emergency, which is the community caretaking function, and exigent circumstances. Now, the government does not even try to rely on the emergency exception, because that one applies when somebody is dead or if somebody is threatened by physical harm or death. Now, in this situation, there's only Mr. Struckman in the backyard, nobody's in danger, and so this exception does not apply. The only one that the government focuses on is exigent circumstances. And the first question, of course, whether the officers had probable cause to believe that Mr. Struckman was committing a crime. The court has a hard time understanding what crime is the government trying to tell us that Mr. Struckman committed. The first thing they say is burglary or attempted burglary. But the court quickly throws those 2 out. The court says, how could Mr. Struckman commit a burglary when the officer who is making the visual observation does not even see any sort of tools? No screwdrivers, hammers, or anything that we usually associate with burglary. So at the very best, this might be a criminal trespass. But the court says, again, in order to establish probable cause, the officers needed to do more than just climb over the fence. When they arrived to the scene, they probably should have asked the neighbor for more information, maybe get her to the property to identify Mr. Struckman. The court also says that the officers could have asked Mr. Struckman for his address, his driver's license. They could have asked him where he lives, whether he knows the particular address that he's at, why he's in the backyard, and so on. And this is, of course, against the backdrop that Mr. Struckman is already telling them that he lives at this particular address and this is his home. So the court says, without more information, there's simply no probable cause to believe that Mr. Struckman committed trespass. At the very best, this might be simply a weak assumption that he's trespassing. And we expect more out of police officers when they're telling us they have probable cause to believe that somebody's committing a crime. Even though there's no probable cause, the court still moves on and talks about the exigent circumstances. Remember those 4 other reasons why we have exigent circumstances as an exception? If the officers would have had probable cause, they still need to show that the facts fell within the 4 previously defined situations. Number 1, the need to prevent physical harm to officers or other persons. Number 2, the need to prevent the imminent destruction of relevant evidence. Number 3, the hot pursuit of a fleeing suspect. And finally, number 4, the need to prevent the escape of a suspect. Okay, now let's discuss these 4 situations. There is no hot pursuit because nobody's fleeing. There is also no destruction of evidence. And there is no danger to the community or to the officers. After all, Mr. Struckman is simply standing on his backyard. And there is no danger to anybody else. In fact, the officers could have continued to stand outside of the fenced yard and guard the area and wait until they get a warrant if they believe that they had probable cause. But of course, they didn't have probable cause in this situation. And finally, the court says that exigency seldom provides justification in the situations where we have minor offenses, misdemeanor offenses, like trespassing. It will seldom provide justification for the officers to make a warrantless entry into the property. So we know exigent circumstances do not apply. So this is the case. Now you understand the Fourth Amendment, curtilage, and how the exigent circumstances apply in this particular situation. Again, officers need to have probable cause, plus it has to fall within one of the 4 situations for the exigency to apply. And here we don't have it. At the end of the day, I'd like to read you the passage from the court that summarizes what you need to know from this case. The net effect of our holding is only that police officers must either obtain a warrant or consent to enter before arresting a person inside a home, or its curtilage, or make a reasonable attempt to ascertain that he's actually a trespasser before making the arrest. That easily could have been done here by asking Struckman to identify himself, a step one would ordinarily expect from the police where trespass is suspected. In the end, the Ninth Circuit says that the firearm should have been suppressed and vacates the conviction. I hope you learned something from this video about curtilage, exigent circumstances, and the Fourth Amendment in general. If you enjoyed this video, give it a thumbs up. Please share my channel with your friends and family. It helps me and it grows my channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.